Okay, I'm going to pick up on a number of the themes that we've talked about during the last few days. I think it's very fitting I come after Yaron's talk because I think there are going to be many parallels and connections between what we've said, although there'll be some significant differences as well. We're going to look at an institution which I think many people know in general terms from the Middle Ages and from other contexts, but we'll look at it in a specifically Polish context. And then I'll try and tease out of there some broader questions about place of law in early modern Jewish history, which hopefully will inspire some discussion. And the institution we're interested in here is the institution of the Jewish judge, or the Jews' judge, the Judex Judaeorum. This was, in the early modern period, already an ancient institution going well back into the Middle Ages. In the region of East Central Europe, we see it first in the 13th century privileges granted to the Jews in Bohemia, Hungary, and Great Poland, the famous 1264 privilege of Boleslav the Pious of Kalisz. I'm not going to go into too much historical background, but essentially as a sign of their jurisdiction over and protection of the Jews in their population, the rulers reserved to themselves the right to try cases involving Jews. Once again, there's nothing terribly out of the ordinary in that in the Middle Ages, in the medieval context. According to Zaremska's research in Hungary and Bohemia, this function eventually devolved into a special Jewish judge, not a Jews' judge, not a judge of the Jews, but actually a Jewish judge or prefect who often served the rulers there as a major tax collector. In Poland, on the other hand, this function remained in the hands of a royal official known as the Wojewoda. There's lots of Polish here today. It took me a long time to learn to say these words. In Latin, the word is palatinus. Now, it may have stayed in his hands for a number of reasons. It may have been due to a more rigorous royal policy towards the Jews. The Polish kings did not sell off the Judenregal in the way that happened in Central Europe. It may also have been connected with a decline in the function of the Voivode himself. In the later Middle Ages, the Polish kings set up a new kind of official known as a starosta, a castellanus, who became much more powerful than the voivoda in terms of his function, although in terms of prestige, the voivoda remained more prestigious. So by the early modern period, in fact, it was the jurisdiction over the Jews that remained one of the few functions of this highly prestigious post of being voivoda, which was granted to the upper ranges of nobility in Poland. They had other functions in towns. They would be responsible for prices and for weights and measures, but the Jews, being responsible for the Jews as a royal official, really was one of their major functions. Running the Jews' court also brought in a not inconsiderable amount of money. So this was also something which the voivodas found attractive. In practice, the voivoda himself would not run the court. He was much too busy being a magnate, a high noble. So he appointed a series of deputies, vice palatines, or in Polish, podvojewoda, which is what I'm going to call him from now on. Podvojewoda. It's a nice word, sounds good. To run the court. Okay? In the voivodstvo, in his region, he would have different sub-regions. Each sub-region would have its own podvojewoda with its own court. Okay? So basically what I'm trying to say that is in Poland, this function of being the Jews' judge, of running a court for the Jews, was held by a non-Jew. Okay? The Jews' court was run by a nobleman. Okay. So I'm going to try and examine this court, as I said, as a way of examining the place of law in the running of the Jewish community. We will, I hope, pick up on a few of the themes which have already emerged in these discussions here. The connection between law, legal status, and the Jews' constitutional position. Conceptions of law, what law was, what law meant, and legal modernization. And I want to try and do this by reading together one of the sets of regulations for the podvojewoda's court that were laid down in 1660. Now, these kind of regulations, we have about a dozen which have survived and been published. Only one comes from the 16th century. The rest are pretty equally divided between the 17th and 18th centuries. We know only of one from the ancient capital of Great Poland, Poznan. The others come from Poland's historic capital, Kraków, and the capital of Red Ruthenia, today Western Ukraine, Lwów. So the one we're going to look at is the one on page 115, issued by a very famous Polish nobleman called Stefan Czarniecki, famous on two levels. He was famous as a great Polish general who helped Poland in a number of its campaigns, including the campaign against Khmelnytsky, but he was most famous in organizing the resistance to the Swedish invasion of Poland in the mid-1650s, setting up a very successful guerrilla campaign to drive the Swedes out. He brought the king back from exile, and he's a great Polish hero. In terms of Jewish history, he was, like many Polish generals, extremely xenophobic. He accused the Jews and the Aryan extreme Protestants of spying for the Swedes, and instituted a number of massacres in Krakow, but most famously in Sandomierz, where about 500 Jews were killed in 1655. So that's just who the man was. It doesn't really have any bearing on the regulations. I mean, what he was and what he felt were one thing, how he ran the system was quite another. So I'm sort of going to just read the text with you to give a basic idea in a few minutes of what the court was and how it was run. Divided this up into sections. So if we want to understand the running of the court, we'll look at regulations 1 to 7. I'll read the first three, and you want to read the others, you will. Okay. First of all, the Vojewoda, which is the official appointed by the Vojewoda to run the court, has the right to hear cases in the Jews' synagogue with the Jewish elders and a scribe. At the same time, a sworn beadle, a Szkolnik, which is a Jewish official, acting as bailiff, must be present at all cases for testimony, which testimony must be valid. Having chosen a scribe sober and knowledgeable in law, the Jews themselves should recommend him to the Vojewoda. The Vojewoda should not oversee any litigation or try cases without the elders. Okay, there are, I say, until number 7, if you want to read, you can read and it'll sort of flesh out what I'm trying to say here. So what's the structure? Okay, we have the Vojewoda sitting in his capital, in Lwów. This regulation deals with a town called Przemyśl, to the west of Lwów. In his place you have the Vojewoda running the court. Okay. He has a scribe, a non-Jewish scribe, whose job it is to do what scribes do. Also to act as a notary, we'll come back to that. This scribe, though non-Jewish, is appointed through a form of negotiation between the Jewish community and the Vojewoda. Now, it's not clear, because there's another regulation a bit further on, which makes it unclear exactly how this negotiation works, whether the Jews choose candidates who the Vojewoda accepts, or whether the Vojewoda sends his candidates to the Jews and they choose one of them. It really isn't clear, but I don't think it's very significant. Okay?
So how do you know that the scribe is not Jewish?
From outside the text. But he isn't. The beadle is, and we have the oath which the beadle had to take, so we know that he's Jewish. So it's already a mixed court. Okay, you have one of the courts I didn't mention is the elders. The Jews from the 16th century fought to have representation on this court. Okay? And this regulation from the 1660s makes it very clear that the Vojewoda should not sort of get into litigation without having Jewish assessors beside him to help make the decisions. So that's kind of the structure of the court, who's working there. I want to be very confusing now and jump to the next set of regulations. I brought a second set of regulations for comparative purposes. So if you jump to page 122 and look at paragraph 3, we'll get a slightly more deeper understanding of how the court worked. It says there, the Vojewoda and the judge should take the oath in accordance with the civil law, and especially according to the statutes of the kingdom, namely Herbold. This was a noble who wrote an alphabetical digest of Polish laws in the 1560s, as is found in those statutes with the heading De Judice, under pain of nullifying their rulings in case the oath is not properly taken. This with the express addition that the judge, present and future, should be chosen from 2 candidates suggested by the urbanists. No, we won't go into all that. That's really going to be confusing. The important point here, what I want to take out of this regulation, is that this is a court functioning as part of a general Polish legal system. Okay? And it's really very important that we understand that. This is not a separate court for the Jews. It's not a sui generis court. It's specific for the Jews, but it's part of the Polish constitution. Okay? I don't know if that distinction is clear, but we'll come back to it a couple of times and maybe it'll get clearer. It may be obvious, in which case I'm sorry for being obvious. Okay. Where does the court take place? The court takes place in the synagogue. I don't know if that's what we read or that'll come a bit later on. Also very important. The Jews have the right to have their cases heard in their own quarter. And in fact, within the synagogue, in one of the side rooms of the synagogue building. So it immediately shows us what we have here is a legal institution which is at one at the same time part of Polish constitution, and the other is something which is home for the Jews.
Is the locus chosen because of the oath? Because in court records they always have to go to take an oath in the synagogue, and it's
not made clear what the reason is, but it's every single one of these regulations specifies it's often more than once. Even in those cases where the oath isn't mentioned, that may have been one of the reasons for doing it.
It says by the synagogue, right?
By, meaning not outside.
The medieval justice often was a cathedral steps and things like that.
Well, I guess it was taken in that part of the synagogue known as the Polish, known as the entry room into the synagogue. That's normally where this kind of thing was done. Okay. Another important aspect is the question of the books. And if you look at number 6 of page 116. Sorry to jump you backwards and forwards. It says, Jewish documents or cases with the record books should not be taken out of the synagogue, but should be kept in a chest with my seal and 2 locks, the key to one of which should be kept by the scribe, the non-Jewish official, and to the other by the beadle, the Jewish official. Okay? And so opening the damn books must have been a real problem. You had to get them both together and they had to agree. But nonetheless, it's still part of this divided jurisdiction. You have the Polish jurisdiction, you have the Jewish jurisdiction, and they are reacting together. Okay. So that's how the court is run. Where it's run, how you deal with the records. Okay? Number 7, once again, also about records, that the Vojewoda doesn't take the records. He hasn't got the right. He may be a nobleman, he may be appointed by the Vojewoda, but his rights here are limited. Okay. Sections 8 to 12 deal with the relationship of this court with the Jewish community. And number 8 is very interesting. Because although we're talking about a court, the regulation says, in the election of the community office and the Jewish elders, whom the Jewish populace, according to custom, elects around their Easter, meaning Pesach, the Vojewoda has no part, only the Jews themselves. What's the interest? The interest here is, of course, that the Jewish community, among the people it elects, is the Beit Din. Right? The Beit Din, the community court, continues to function alongside this court. And this regulation is trying to distinguish between these 2 jurisdictions. They're separate jurisdictions. You have the Jews' court and you have the community court. Is that clear? No. Not at all. Oh, good. No, I'm not. I'm saying that why in a regulation to do with legal matters, all of a sudden, is the regulation saying that no one can interfere with the Jews' community elections?
Because the elders were already part of number 1. They were going to be part of the
No, it's not what's going on. What's going on is that the Vojewoda has no right to interfere in the internal running of the Jewish community.
But we do know that the Kehillah was elected at Pesach time.
Yes.
The elections for the Kehillah, not for the Beit Din, but for the Kehillah.
But they're elected together. I'm sorry. I thought that was obvious. We have election records from I don't know, a dozen or so Jewish communities where we see that each time at Pesach you elect the elders, you elect the Beit Din, you elect the people who run the guilds and so on and so forth. All elected together. How's it elected? It's elected like everything else.
Out of a selected number of candidates who had to have smicha and so on and so on.
Was there an outbreak?
The Beit Din was the rabbi.
And did he remain over several, 3
Yeah,
years?
yeah. When the rabbi was elected, he was the Beit Din. That's how it was. Yes. I'm sorry. This is
You took us to number 3.
Yes.
We read number 3, and we read that the Voivode is sitting there with elders.
with elders.
Okay, are those elders not the same elders that we're reading about in number 8? Aren't your some of those are
How do you know?
different?
The same word.
Sorry.
It's the same.
I know it's the same term, but it still isn't the same. I know this because, okay, first of all, language. Let's do this. Okay, look, it's methodologically important, right? Get it right. Get it right. Language. The Polish sources are describing a Jewish reality with which they are not intimately detailed. The language that they use to describe that reality is notoriously inconsistent and not 100% accurate.
Can you show us in clause number 1 and clause number 8 what the word is?
Yeah, the word will be starshin, if I remember rightly. Seniores.
And in the
Skenim or Parnasim or Rashim or whatever. Yes.
in the two different texts, in the first one there's a pod vojevoda. The second one there's a pod vojevoda and a judge. Isn't
Right.
there?
Yeah, we'll go there. I'll go there too. Don't worry.
So
One thing, no, I can't answer the methodological issue here and talk about that one at a time. Okay. The starship, the elders, as far as the Poles are concerned, are the people who run the community, which is everybody together. Okay. The people who the community sends to sit with the pod vojevoda are called the elders. The people who run the community, as far as the Poles are concerned, are called the elders. They're not making a distinction, and it would be not terribly reasonable to expect for them to do so. However, we do know that assessors, part of the community leadership did go and sit with the pod vojevoda from time to time. And I'll deal with that in a moment. But when he's talking about elections, he's talking about elections to the whole community. Now, if you want...
Which includes judges.
which includes judges. I can take you to the next one, number 2. Maybe that will make it clear. On page... This is getting really complicated, aren't it? Yeah.
Even if the second, if 8 is referring to a different institution that includes judges,
Yeah.
do they have external evidence, even though from some other aspect of the document that they were trying cases, not just governing?
Read number 2 on page 122. The elders of both communities, meaning Lwów, having stipulated the elections to the leadership as far as time, custom and regulation are concerned, and without any impediment from me or the pod vojevoda, are to hold the elections in accordance with the rites and customs peaceably and without the slightest hindrance. These elected Jewish elders must try the local Jews of Lwów, both urban and suburban, that's the 2 communities, as well as the foreign Jews of the entire Lithuanian Voivodstvo, faithfully and justly in accordance with the old and ancient customs, rites and orders.
And that's not with the...
No, that is the community court. I'm sorry, there are things that are obvious to me and not obvious to anyone else. It's not at all obvious. Keep going. Okay.
And you know so much more about this than we do, but just at the face of it, we even had in the absence of the Voivode, the scribe along with the elders should oversee all the case and the affairs.
Right.
So at the face of it, you would think that he's usually absent and they're usually just doing it.
Okay, you're right, and we will. I mean, I'm trying to get this organised so we have some basic structural understanding, and then we can get into the details. So I will definitely answer your point. Just let me take.
Wait, just give us just a real quick thing. So can we assume that the reason that you're so sure of this is because you know about cases where these 2 different courts exist at the same time that conflict over something?
Listen, the 2 different courts are these. You know what? Forget the text. I'll talk for a little bit, and then we'll go back to the text. The 2 different courts are these. This is something that we know right, from every Jewish community. The Jewish community has its community council, which includes the people who run the community, the Parnasim, and that whole organisation. In addition, it has Beit Din, or very often in Poland, 3 Batei Din. Okay? The president of the rabbinic court is the rabbi himself. That's his title, of Beit Din. And 8 other, normally respected and educated Jews who sit with him and try the cases. The rabbinic court tries cases between Jews on all issues that come up between Jews. Okay? I don't think I've said anything, but...
It says that in your text.
Right, okay, yeah. That is what we know. Now we have... Oh, correct. Yes, Ken. Clarify.
My judge may not try Jewish.
No, Ken, we're not looking at the text yet. I've got to get this sorted out. I want your definitions. I will give you a definition of everything, but let me get it sorted out. The other court that we're talking about.
The sources where you have information about the structure, so that we know.
Every Pinkas that has survived, but in particular for this period, Pinkasim from Poznan, which we have in manuscript, and the records from Krakow, which we have published by Balaban and others, describe this reality. The Pinkas of Tiktin, which Nadav published a few years back, has the same reality. If you read Tradition and Crisis by Jacob Katz, which is not a book I often recommend, no, it's beautifully translated in a wonderful afterword in the new edition. But Katz does manage to give us a wonderful description of how these communities worked, and there isn't anything really new in what I've said until now. So what do we have here? What am I going to describe and what we look at the text about? We have here a court which is based on the Polish legal maxim actor sequitur forum rei, which means that the plaintiff has to have his case heard in the court of the defendant. That is the basis of how the Polish legal system worked in general. I understand it's the basis for the jury system, that you have the right to be tried before your peers. In this case, it means that, for example, a Polish nobleman will be tried before a noble court. A clergyman will go to the clerical court. A burgher, a townsman, will be heard in the municipal court, or the Magdeburg court as it's known in Poland. A Jew, when he is prosecuted by a non-Jew, will go to the court of the Jew's judge. This is what we're talking about in this text. Okay? It's a special court system set up for Jews. It's very complicated because you have these two jurisdictions running side by side. In fact, you have a lot more jurisdictions running. I can see Magda smiling because she wants me to talk about them and confuse the issue even more than I've done so far. Is that okay? So that's the situation. If a Jew has a case with another Jew, according to the system, he goes to the community court. If he is prosecuted by a non-Jew, the case goes before the court that we're looking at here, run by the Vojewoda. If the Jew wants to prosecute a non-Jew of a different status, which is to say either a nobleman or a burgher or whatever, he has to take that case to their court and prosecute them there. That's how the system works. It's the same system for everybody. There are many, many exceptions to this. This is early modern Poland, right? You have one rule and 100 exceptions. And the jurisdiction of the Vojewoda is limited, as I've already said. I may get to that later on. I just want to get the picture clear before I go any further. Let's look at number 21.
17?
Oh, 117. No, 19, 20 and 21. 19. And should someone from the Jewish populace disobey the elders in the matter of payments, decrees they have given, or in other issues, the Jewish elders should try him. The Vojewoda must not interfere with their court nor come to his defense, but on the contrary should cooperate in executing the verdict of the elders. Now, on the face of it, this is reasonable and clear. We have the two jurisdictions. If one of the Jews disobeys the elders, clearly this is an internal Jewish matter. It should go to the community court, and it's all right. On the other hand, what this thing is telling us, what this stipulation is telling us, is there is a problem here. That we have two jurisdictions, and there's a problem. Otherwise, you wouldn't have to say that the Vojewoda shouldn't get involved. You only tell the Vojewoda not to get involved if he is getting involved. So having tried to sort things out, I'm now trying to complicate them at one stage further. So, community court, Jews judge, okay, parallel jurisdictions that we're beginning to see some overlapping between the two. So far, so good?
In practice, not in theory.
In practice, yeah. In theory, they're not supposed to overlap. And here's the man saying, no, you shouldn't. This should be separate jurisdictions. And it's a question, what happens? Let's look at number 8 on page 123. And we'll see another aspect of the Vojewoda's court which develops. There are vagrant Jews who, having no occupation, get into trickery, i.e. they serve in collecting the taxes of various taxes, szelążny, chopowy, and the lease, but collect more than is due. Therefore, in an effort to ensure that they do not harm people, I order that none of these Jews should dare to serve without the knowledge of the elders, and that the Jewish elders of both communities, the urban and the suburban, ensure that anyone who takes up these services is a man of virtue and not suspicious. In this way, they can recommend him to people that he will not deceive or trick them, and will carry out his duties with fairness. Okay? The penalty for failing to act properly is severe, and is put in the hands of the Jewish elders of both communities, so that they severely punish those who act wickedly in these matters without any respect of person. It's going one step further. Okay? This court is not just trying cases between Jews, but it's beginning to oversee the Jewish community. Okay? I'm going very fast. I'm leaving out steps in the middle. It probably isn't wise, but I think in the time I have, that's all I can do. Two courts acting separately. The Vojewoda's court is beginning to encroach on the functioning of the community court. And here, in the 1690s, we can see that the Vojewoda's court is beginning to give orders to the community how it should run itself, which is not strictly a legal matter at all. We have the question of two jurisdictions which are actually beginning one to encroach upon the other.
But these are individuals who are operating in the general world, no?
Yes, but what's happening is that the Vojewoda is giving an order to the elders of the community that they should register the people who take on these positions. That's not a legal. That's not a legal function in that sense that we've been talking about. Not a forensic function.
Also, in some sense, they're creating the court, right? I mean, they're authorizing the court. They're creating the court. So they're defining the jurisdiction.
They're defining the jurisdiction of
the court.
Of the community court.
Of the community
Yeah, exactly.
Court, right?
Yeah, precisely what I'm trying to say. They are beginning to encroach. The ability of the community court to run its own affairs is becoming limited.
But you created the court, right? It's a typical move.
Yes, I'm not saying it's not typical. I'm just saying, okay,
right.
one
it's
thing.
It's like federal courts. Congress creates it, and then it says you can only do this, you can't do that, you can only do this, you can't do that.
Yeah. Okay. Right. Okay, so I have kind of in a very sketchy way. I'm sorry, I took too much for granted in preparing. Okay. It's a mixed jurisdiction. It's Jewish and it's non-Jewish. And a balance has to be kept between the two. And it's a very delicate balance. Okay? The regulations are trying, on the one hand, to keep the Jewish judge out of internal Jewish matters, out of the elections, out of the running of the rabbinical court. On the other hand, they're beginning to define the limits of the jurisdiction of the Jews' court and what the Jews' court can do and what it can't do. Okay, so it's this mixed nature of this jurisdiction which I find fascinating and important. Come on, Lois.
I'm very confused about the clause you just discussed, number 8, because it's about the elders.
Right.
Now you've already told us there's two kinds of elders. There's the elders of the community and the elders of the court.
The Dayanim. Okay, yeah,
maybe I'm missing something, but I don't see here that this is really. Could you just spell out exactly where it says that this is defining the jurisdiction or the limits of the court, of the Jewish court, as opposed to the Jewish community in administering its affairs? To me, this looks like kahal and not beit din.
Yes, you're right.
So what does that do to your last point?
Nothing at all.
Why not?
because the Vojevoda is still limiting the jurisdiction of the Jewish community.
Of the community as a whole, yes.
Whether it's just the court or whether it's the community as a whole is not relevant at this point, I don't think.
I think it might be both.
Okay, listen, let me finish what I'm going to say, and then I have my sleeves already rolled up, but I'll roll them up and we'll bang. Okay. How did the Jews, what was the Jews' response to these courts? How did the Jews deal with this mixed jurisdiction? This isn't so much from here, this is from the literature. Well, what we know is in the earliest, even what we know from the Middle Ages, and certainly from the 16th and early 17th century, the Jews' policy towards these courts was to have assessors, was to have the elders, who we found so confusing here, sit on the court, together with the Jews' judge. Okay, the judicial. This was a way in which they could guarantee that the justice that is meted out is suitable for Jewish defendants. Otherwise, what's the point of a court like this? The problem is that from the records that we have from the 17th and 18th century, these assessors don't often turn up. They're not. It's not a very functioning thing. They have the right, but it's not a right that seems to have been used in practice. In the 17th century, the Jews have a new tactic, which we do see here on number 15 on page 116, when it talks about the Jews leasing the court from the Vojevoda. 116, clause 15. The Jews lease the courts, which means that they give the Vojevoda, the Podvojevoda, and the scribe, and everyone involved the income that they're going to get, and run the show themselves. Okay? This is a different strategy. The first strategy that we see in the 16th century and before is to have Jewish assessors sitting in the court, these confusing elders. In the 17th century, we see this attempt to lease the court and get the non-Jews out of it entirely. 116:15.
No, that's only a lawsuit with another Jew. It's not a lawsuit that makes...
Wait a minute. What? I don't know if I've missed. Wow, I've missed something very important. Okay.
15.
Okay. In the 18th century, this idea of leasing the court dies out, and in fact the court runs without Jewish, from what we can make out, without any Jewish input at all. It's run by the non-Jewish judge, and that's who runs it, and the Jews have no input. Go on, yep.
A question about that. If we read somewhere that they are supposed to be trying to follow the customs of the community, which I understood to mean that somehow the Jewish judge is trying to apply whatever is understood to be Jewish law. I don't remember where that was. And that's why I sort of figured that it made sense that the elders had to sit with him.
Right. Well, that's the idea of having the elders there, is that...
If this fades out by the 18th century, does the kind of decision-making that's being made and justice that's being offered then divorce itself from Jewish law? Or at that point, does the Jewish... at that point, presumably no.
No, they don't know Jewish law. No. Right, so that's no, you're right, they don't know. I mean, that's what happens in the 18th century. It becomes a non-Jewish court where Jews go to get justice.
What was the initial concern about law? I mean, you mentioned the the concept of the jury of one's peers.
Right.
The notion is the incident, what happened. I mean, the two pieces to
it's what you happen and how you interpret what happened. I mean, there's not a question of determining what happened that's a problem. You don't need the Jews or non-Jews to determine what happened in a case. What you need Jews for is to interpret it and see to what extent...
Well, not necessarily. I mean, we shuffle cases around because we're concerned about who is deciding the facts in one way or another with prejudice, right? To try, to sort of decide that something happened or not, right? New York citizens don't want to have to go to New Jersey, and New Jersey don't want to go to New York, and it's not because the laws really going to be so different, but because the facts and whether or not you're going to decide for the plaintiff or not for the plaintiff to decide that he really did run through the red light or not, it might vary with the prejudices. So.
Oh, I see what you mean. Okay. Interpretation of evidence.
So it doesn't really require, right.
It's not interpretation of facts, interpretation of evidence.
Per se, in terms of Halakhah.
Right. Okay.
Were there ever supposed to be Jews on the court? I thought it was just the non-Jewish judge.
Non-Jewish judge. He would sit with assessors, Jewish assessors.
That was a later.
That was earlier. That was earlier.
That was earlier.
Yeah. No, I can see this is. Yes, right. Okay, I think I better give a few words about the legal system again. As I said, cases between the Jews go to the community court. Cases where a Jew prosecutes a non-Jew go to the non-Jews court. Cases where a non-Jew prosecutes a Jew go to the Judex Judaeorum's court. What happens when you want to appeal from these courts? Okay, it's a legal system. Jews have two ways to appeal from the community courts. They can go to a regional Jewish court, the higher Jewish court. In Poland you have the community councils and the Council of Four Lands, and the Jews can appeal to a higher Jewish court and take their appeal that way. Or the Jews can appeal from the community court to the Judex Judaeorum. That's another way that the Jews have of settling their cases. The Judex Judaeorum functions as a court of appeal to the community court. Once again, it's what I'm not doing at all well here is trying to show that this court standing really between the two worlds, connecting the two worlds, the world of Polish Jewish students and the world of Jewish students, in one way or another. What did it mean? What was the constitutional significance of this system? I think it's very significant. I think the most important thing about this is that it means that the Jews have a court system like the nobles have, like the burghers have, like the clergy has, like the peasants ought to have but never do because they're peasants. And no other minority, ethnic or religious, in Poland has this system of courts in the royal towns. Armenians have internal courts. They have courts for cases between Armenians. So do the Scots. But a court where, a separate court where if you are accused, prosecuted by a non-member of the group, you have your own court, they don't have. This is something just for Jews.
Could you repeat your last sentence?
I could if I could remember what I said. The only minority group to have a separate legal system when they are prosecuted by non-members of that group is the Jews. This means that in constitutional terms, the Jews have the same footing as the nobility, the burghers, the peasants. They are one of the constitutive estates of the Polish kingdom. Okay? This is not to say they were a corporation, because we've heard from Ken Stowe that the Jews were not a corporation, but they were an estate here. This is enormously significant in terms of the status of the Jews in society.
But isn't that a function of their numbers? I don't know anything about Armenians in Poland, frankly.
I'm sure it's a function of numbers and importance. Okay. What about some of the legal significance of this system? Well, what's interesting to me is the question of appeals. Because, okay, when a Christian accuses a Jew and the Jew has his own court, he goes, and that seems a reasonably logical thing to do, and it makes sense. But if you have a case in the community court and you appeal it to this court rather than to the Jewish court, I think you're making a significant cultural statement. I found two cases mentioned that I can bring. In 1755, one Yoshio Itzkovich, Joseph, son of Isaac, and his wife, brought Moshko Zacharievich, Moshe ben Zachariah, and his wife, Chaya, to the Vojewoda's court to sort out a dispute about a dowry and the disposition of places inside the synagogue. Okay, presumably part of the dowry is what places they had. So the man who is deciding who sits where in the synagogue is in fact the Judex Judaeorum, the Jews' judge. In the second case that I have, Itzko Kravietz, Isaac the tailor, sues his son-in-law, Moshko Zwotnik, Moshe Goldsmith, for attacking his son in shul. Okay. The court deals with the criminal aspects of this case and then adds, for defiling the synagogue, he should make the normal expiation to the Jews. That's not in the words, it's not very significant. But symbolically, the Jew's judge is imposing a penalty on a Jew for defiling the synagogue. There's this kind of, it's more than just nibbling away, to my way of thinking. There's deep cultural significance here. 1754.
Where?
It's registered in the Lwów books. I don't know whether it's actually in Lwów itself or one of the communities around, I couldn't say.
There are a ton of cases like that.
I know there are.
Not treated, in fact, in synagogues, but in Christian secular courts.
No, okay. Where I want to take this, and you can get back to me if I haven't answered what you're saying, is that the cases were tried according to non-Jewish law, and what you're talking about is exactly the same. No, Magda?
Right, except that the place is different and they...
Okay. You asked, we'll talk about it. When I finish talking, we'll discuss it, because it's important. Which means that these Jews preferred a non-halachic settlement. Comes back to what Yaron was talking about. Okay? And we're not just talking about matters of money. These are things that really come into the heart of the Jewish community, the way things are run, the way the synagogues are run, and so on. Why? Well, I think Yaron gave some of the answers. I'm sure that this court had much better ways of enforcing its rulings than the rabbinic court did, which really only had the cherem, which was pretty much a broken reed, certainly by the 18th century and even before. It may have been less corrupt than the rabbinic court. It may have been harder to sway the verdict, or alternatively, you may have been able to get a different kind of corruption. You know, you can choose the corruption which is most suited to your needs, but one way or the other, the question of manipulating, it's a different form of manipulation. Benjamin Cohen, who wrote a thesis on this, suggested that it might have been a class thing, that only wealthier Jews preferred to use this court. I can't back that up at this stage. But what I'd like to say, and that goes back to what Yaron said, although I'm not sure he'll agree with me, I think that this system, and certainly the use of the system for appealing, suggests that the role of Halakhah in Jewish life was not as central as we like to think it was. I think that when it came to running most aspects of daily life, Halakhah was an option, but only an option. We like to think of Halakhah in a different way. I think, I can talk about why I think it happened, but maybe I won't do it now, because I won't. It also suggests, I think, which I came back to something Richard said when he spoke, and I sort of mentioned it as a question. It also suggests that Halakhah did not play a constitutional role in Polish Jewish life. Scholars like to say that the Jewish community in early modern times ran, certainly in Poland, and that its constitution was the Halakhah. Well, in fact, the constitutional basis for the functioning of the Jewish community, if we use this perspective, was Polish law, not Halakhah. Halakhah was only a very limited, one of the limited forms of law that we know about, and that Jews chose to use or chose not to use. So I think we have to start reconfiguring how we understand Halakhah as functioning in the pre-modern Jewish world. Yes?
I am predisposed to like where you're going with that.
Good.
But I have a question.
Something, yeah.
I have a question about the specifics. So in the second privilege, the 1692 privilege on 122.
Which page?
Page 122.
Yeah.
I'm still trying to understand two things.
Yeah.
One, since both of these privileges refer to Jewish elders sitting with the Palatine deputy,
Vice Palatine.
your guy, both of them refer to those, but you have also cases where both they and the other elders apparently have to sometimes sit together, two uses of the elders.
Yeah.
In this specific passage 4, paragraph 4, it says, "My judge may not try Jewish cases in his residence, but only at the legally appointed site by the synagogue. The Jewish elders should sit in court with him and cast their vote according to their own understanding, following ancient custom and laws of this community."
Right.
Can you explain to us how you read that? What do you think that means exactly?
I think, as I understand it, it means that when it comes to interpreting how the Jewish defendant acted, okay, that they will do that according to their understanding of how Jews act. Whether that is a halachic thing, where Halakhah explains how they do it, whether it's a customary thing, this is how Jews act. And this will help explain and counterbalance evidence given by non-Jews, will be inclined to put a different spin on the facts being brought to case. I mean, that's how I understand it.
Voting.
It was voting. They cast a vote. That's a very unclear language. I think...
How many votes did the...
Well, exactly. Yeah, exactly. What does voting mean? And do you have to listen? And is it a majority decision? And my feeling is that these are assessors. That's what's another language that's used, which means that they give advice.
So does it express their opinion, perhaps?
It could be.
Supposed to cast their vote?
It could be. The language is of casting a vote, which is why I left it as it is, because it's not. It's hard enough with the language they have.
Is there a different term for voting or for just expressing an opinion?
They could have had them. They could have used the language more clearly, but in so many places here, they could have used the language more clearly. Okay, go on. It's fine. No, it's okay. That's how we're doing it.
I'm sort of mystified by something that you said, which I agree with, but it's, coming to this realization how little people in the past have paid attention to this legal world in which Jews live. And you're quite right. Past historians do see, well, the Polish Jewish community lives by Halakhah, lives by its own authorities. And yet it should be so obvious to us that they're going to have to deal with things. And the difference that seems to me here, though, that we have to follow isn't whether Jews are using external law in their issues. It's the degree to which they have the option of using external law, the degree to which they have the choice of court to which they're going to turn. Are they going to the sub-Vojevoda simply because they want to, or because they have to? And by the way, because a lot of this stuff, it's used communist stuff. I picked up and showed Magda here in number 11 in the text that I brought yesterday. It says very clearly, actor debet sequi forum rei. It's a principle. I mean, it's a general legal principle, and that's the point. They brought it into Poland, and you've got to expect to see that kind of thing. So, in a weird kind of way, we're discovering hot water, but in a positive sense. I mean it positively. That is, we're discovering what we should have seen all along. It hasn't been enunciated.
I hope that's good.
Yes.
Okay.
Yes, that's very good.
I was saying, you mentioned in your text you had a I can't remember the Italian name of officials that looked suspiciously like that we're looking at here, but we have to do more comparative research. Okay, more people. So Magda, Suzanne, Bernie.
I just wanted to say that supporting your thesis in some way, that even the strongest community that was perhaps most studied, and we have the Pincus from Krakow, is one that if you actually go to the court records where the Jews are not supposed to be, they're all over suing each other. Not just in the court of the Wojewoda, but in the municipal court, in the castle court, and under different fora. So even the Krakow community, that is this quintessential center of rabbinic learning and autonomy, so to speak, is one where...
Absolutely. I mean, okay, I focused in on this particular court, and I said at the beginning it's a court of narrow jurisdiction. There are lots of other courts in Poland, and the Jews, I mean, I say I had enough trouble looking at this one. The Jews actually use many other jurisdictions for first instance cases, for appeals. There are cases where the Jews aren't allowed to get to this court because they're under the jurisdiction of a different nobleman. They have to go to his court. It's very, very complicated. I really focus in on this one because I want to make the points I want to make through this. And those other cases only strengthen what I'm trying to say. You have to believe me on that as well.
I mean, in the case of Tuscany, there's an exact parallel to this. I mean, absolutely exact. And the appellate figure who is understood as being there for cases between Jews and non-Jews. Right? That is his job. He has nothing to do with the Jewish community. He is a separate court in his own right. And if you appeal to him, if you appeal his case, you appeal to the Grand Duke himself. But this figure is there, obviously, there seems to be no doubt, simply to solve the problem of individuals with different legal statuses, and therefore you need a court that can handle both. Right. And to avoid the necessity of forcing Jews to go through the procedural rules of non-Jewish courts, which they always consistently seek to avoid. That's the big bugaboo for Jews. They want summary justice. They don't want this kind of procedural thing. That said, we're talking about a relatively small community. I don't see any constitutional, although I know no other parallels to the Jews in this case. I know of no reason to argue that it's a constitutional element. It's simply a mechanism for solving a practical problem. And the fact that in Poland you see that it's so often that people are just using whatever court system it does, what it really reinforces is that the court system is not so much a fixed set of jurisdictions, but rather you kind of negotiate where, who, how any case will be done.
Okay, I can't talk to Tuscany because I don't really. 6 minutes. Okay, I don't really know the case, but here, I mean, it is so clear. The parallels between the court systems of the different estates is so clear, and the fact that no other group apart from the estates and the Jews have it seems to me to be something that it's really hard to ignore. I don't think this is just the Jews needing summary justice, because from Magda has said what we know anyway. The Jews in Poland, and I think in Germany, from we heard from Barbara, have no problem going to the general legal system, which can be extremely protracted and difficult. So I'm not sure that I'd take that point the way you put it. Anne?
I want to come back to this big point that you made, if we can, just for a second. This idea that you're pointing out that Jews here, as we've seen in several other cases, are somehow preferring non-Jewish courts at some times. And you're suggesting that there's this broader idea that means Halakhah wasn't maybe as central or as all-defining of their sense of law, right? Yeah. So first of all, you said that you don't want to talk about why this happened, and I want to ask you why it happened. And second of all, I want to ask, I think because we haven't had this kind of question very much in this conference yet, but is this early modern? What makes it early modern? How is it different from the medieval situation? I mean, medieval Jews were not unaware that there was a broader legal context, and they weren't uninvolved in...
Okay. Let me answer that very, very briefly. It's very... okay, I'm just going to... In 4.5 minutes, yeah. It's a very broad topic, and I'm going to have to be even more sketchy than I've been until now. But I think the breakdown of the structures of the Middle Ages, the disintegration of forms, which really developed at the end of the Middle Ages, came to their highest form of development in the 16th century, and then through the 17th century begin to decline, is one of the things that marks early modern Jewish history. And I think the attitude towards the rabbinate is a case of that. I think the attitude towards Halakhah is another case of that. And I think if you look past the early modern period, what we don't often do in this workshop is to look at the modern period. We like to say what happened between the medieval period and this period. But if you look into the 19th century, what you actually see, I think, is a reconstruction of the rabbinate in a new form with much more power over the community which it rules. And that Halakhah is transformed in that process. I think, I mean, it is a big thing to say when I've got 4.5 minutes. But my feeling is that Halakhah takes on a new sociological meaning or function in the 19th century as defining Orthodox Jews. And that's how we understand Halakhah, as a defining thing. And it worked. It's worked extremely well in the modern period. And we read that back into an early modern period where Halakhah played a different role. Now that really is a big statement and one we can't argue. Can I say one more thing about modernization, and then I'll stop and you'll have exactly 30 seconds to argue with me. It's also another very big point. Yesterday we looked a lot at the Western European Sephardic Jewish model of developing legal attitudes towards Jews as representing the modernizing trend Jewish history. And I think that way of looking at things had an obvious attraction for us in the early 21st century. It seems, and then certainly the Sephardic Jews as they live between worlds and all that, it's something that appeals to us in our reality. But if we look at what we would term the modern period, in the strictest sense of the term, I guess from about 1750 to 1950, my feeling is that that model, the Sephardic Jewish model, is not the dominant one. The dominant model is this Polish one. It seems to me that in the period from the French Revolution onwards, in the places where the majority of the Jews lived, certainly in Europe, I'm talking about what Yaron's part of the world, the struggle was to get back to the kind of integration that I've tried to show here, whereby the Jews are at one and the same time legally integrated into the constitutional structures of society, but where they don't lose their separate status as a group. Okay? In many respects, you could argue that Jewish modernity in legal terms is an attempt to square this circle, which is very difficult after the French Revolution. I mean, Ken quoted Abbé Grégoire yesterday. To the Jew as individual, everything to the Jews as group, nothing. Sorry, Abbé Grégoire. No, it wasn't? Who was it? Now, Napoleon solved the problem. As I understand it, Napoleon actually did solve this problem. He set up the consistoire system, which was a system that allowed the Jews to be both, to be citizens and a recognized group.
Talk to French political theorists. I don't think it's
okay. Okay, then perhaps it wasn't. But maybe it's the closest. Maybe it's the closest that modernity got to solving that problem. And maybe the failure to solve that problem is one thing that actually marks out modernity. Is that what the Jews in early modern Poland managed to achieve, which was integration as a separate group, is something that never happened in modernity, and that marks out modernity from the early modern period. Thank you.